Sir, I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the Black Robe.
Welcome back, Courtroom Watchers. Today we're diving into part 4 of the unforgettable case of Frank Micho, also known as the man who treats court like an improv stage. If you've been following along, you know this saga has been bouncing between judges like a game of hot potato. Judge Green, Judge Oakley, and now we're back with Green again. Each time, the tension builds. And at the heart of it all, a defendant who insists he's not just Frank Micho, but the beneficiary of the Frank Micho estate, trying to appoint the judge as a trustee. Oh yes, this is sovereign citizen logic at its finest. But beneath the wordplay, the stakes are deadly serious. Firearm possession by a felon, concealed weapons, and a felony firearm charge. And let's not forget, this all started at an airport, one of the worst places to play games with jurisdiction. Buckle up, because what you're about to hear is equal parts comedy, frustration, and high-stakes courtroom drama.
This is 210736FY. This is State of Michigan versus Frank Micho. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Micho. I am the beneficiary of the Frank Anthony Micho estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the threat, duress, and coercion.
Thank you, Mr. Micho. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple preliminary matters.
Before we do that, Mr. Micho, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one is the jurisdiction that the court is operating upon.
Judge, I'm gonna object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm gonna object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Micho make his record.
Yes, ma'am. Okay. Constitution, the Sixth Amendment grants me the right to know the nature and the cause of the action. And I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggest more than one thing.
Oh, yes, the jurisdiction of the court.
Here we go again. Micho is back on his favorite subject, jurisdiction. Sovereign citizen defendants often believe that if they can trap the court in some legal word game, they can just walk free. Spoiler, that's not how it works. The prosecutor immediately objects because this exact question has already been ruled on by not one, but 2 judges. Yet Micho pushes ahead, asking as if repeating the question enough times will magically change reality. Here's the kicker. His charges are crystal clear under Michigan law. This isn't about maritime law, commerce, or corporate fiction. It's about a convicted felon bringing a gun into an airport. What do you think? Does Micho truly not understand? Or is he stalling for time?
Yes.
What's next?
Is this going to be criminal, civil or criminal? And I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So,
Mr. Micho, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.740124 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise in a vehicle operated or occupied by said defendant, to wit, a Range Rover, contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempted to commit a felony, to wit, felon in possession of a firearm, contrary to MCL 750.227B. There is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges, indicated to you that this is a criminal matter. The court's question back to you, sir, is are you prepared to proceed with the exam in this matter?
No, you still haven't stated the jurisdiction.
Notice how the judge doesn't just say, "You're charged with a crime." She reads the charges in painstaking detail, citing exact Michigan-compiled laws, MCL 750.224F, 750.224, and 750.227B. Why? Because defendants like Micho thrive on technicalities. By putting it all on the record, the judge makes it impossible for him to later claim he didn't know what he was being accused of. And it's brutal when you line it up. Not only was he already convicted of drug offenses and weapons violations, but he allegedly carried a pistol right into Detroit Metro Airport. That's the equivalent of running a red light straight into a police station parking lot.
I've identified this court as the 34th District Court to you before, sir, and I will renew that indication to you. Are you prepared to proceed with the exam?
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as trustee for the.
This is the turning point. The judge simplifies everything into three crystal clear choices. Proceed with the exam, waive it, or adjourn. She's trying to strip away Micho's smoke and mirrors. But instead of giving one of those three answers, he launches into another question, effectively trying to stall the legal process. Judges have to walk a fine line here, give too much leeway, and the court becomes a circus. Cut him off too fast, and the defendant claims bias. What would you do in her shoes? Indulge him or shut it down?
Mr. Michaud, you're not under any threat. This is a court. You've appeared this afternoon. This case has been called, and if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the courts, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And you, while you're asking me, you also telling me that we're about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you,
okay,
but
so,
I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
I just want to ask you, far as, hold on one second. I want to read this for you.
No, sir. You had a question. What is your
Okay.
question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party and interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon, we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but
Okay.
this says that possession of a deadly weapon is a commercial crime, so we have to I need to have a better understanding if this is a commercial crime. You said this is a crime, and there is no injured party where I hurt anyone. You haven't gave me the right to face my accuser, and it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So how, I understand that commercial is civil, but you telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you operate under? Is this
Mr.
civil or criminal? Because it doesn't make sense.
Classic sovereign citizen move. When the judge insists on moving forward, Micho cries threat and coercion. He argues that simply being asked to comply with procedure equals being threatened. This is gaslighting at its finest. He flips the narrative to make himself look like the victim of judicial bullying. But the judge keeps her cool, clarifying that no threats are being made. It's a masterclass in judicial patience. Let's be honest. How many of us could stay that calm if someone kept accusing us of threats while refusing to answer simple yes or no questions?
You're asking a compound question, so I'm going to try to answer it. Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27/7211. All crimes are commercial. So I still I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threat and duress of coercion, I appoint Sullivan as my trustee for the.
And here it is, the sovereign citizen's greatest hit, claiming all crimes are commercial under federal code. Micho cites CFR 27.72.11, insisting that crimes must involve a corporate injured party. This is straight out of the sovereign citizen playbook, cherry-picking obscure federal regulations and applying them where they don't belong. Here's the truth. 27 CFR 72.11 deals with ATF property seizures, not state-level gun crimes. It's like quoting a recipe book in a murder trial. Entertaining? Yes. Relevant? Not in the slightest. Drop a comment below. Do you think Micho actually believes this stuff, or is it all just an act?
Was in receipt of a sealed copy of Mr. Michaud's record, and Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, And it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice. Your previously entered bond with any conditions will continue